Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to the new subscribers and welcome back to our loyal listeners. If you're not yet subscribed, especially on the YouTube channel, please hit that like button and then click subscribe. It doesn't cost you a thing and it helps the channel so much. If you are here, you know that I've covered the Darlie Routier trial or the trial transcripts from the very beginning. At this point, the defense has rested and the state has called a private investigator / former homicide officer who interrogated Darlie at the Rowlett Police Department on the day that she was arrested. And his name is William Parker. And he said that when he accused Darlie of her children, and he did this a minimum of 6 times, we'll learn what her response was to each of these accusations. So let's get on with the testimony of William Parker. And the court says, all right, today is Thursday, January 30th, 1997. All right, let the record reflect that these proceedings are being held outside of the presence of the jury and all parties in the trial are present. Mr. Hagler, and Mr. Hagler again is with the defense team. Your Honor, at this time, we would object to any testimony through this witness, Mr. Parker, who, it's our understanding, interrogated the defendant, after which time an arrest warrant had been issued for her. And it is our understanding it was a lengthy interrogation. And we anticipate that Mr. Parker is going to be testifying to the oral statements made by the defendant. Your Honor, we're fully aware of the provisions of 38.22, Section 5 of the Texas Code of Criminal Procedure, which allows the admission into evidence of certain statements, more specifically voluntary statements, that has a bearing upon the credibility of the accused as a witness. And we don't quarrel with that naturally. But our position, Your Honor, is that if they intend to elicit testimony through this witness, it should be limited, must be limited, as to only those statements of the defendant that has a bearing on her credibility. In other words, impeachment-type testimony, as opposed to allowing them to go through an entire eliciting from this witness any and all statements, interrogations, and what have you made by the defendant while she was interrogated by this individual while she was in custody. And we would further urge that even though Mr. Parker is not presently a law enforcement officer, he was there acting as an agent of the state. And therefore, the provision 38.22 is applicable. The court then says, anything, Mr. Davis? And Mr. Greg Davis of the prosecution says, no, sir, I don't have any response to that. And the court says, all right. Well, the court yesterday found that the witness, that Mrs. Routier had been properly Mirandized and the statement was voluntarily given. So the court would admit Mr. Parker's testimony and enter appropriate findings of facts and conclusions of law in this area, and place it in the record of the trial. And I assume you will object to this? Mr. Hagler says, well, we have not really had any hearings on the voluntariness. Of course, apparently there is no dispute about the fact that she was given Miranda warnings. And the court says, all right. And Mr. Hagler continues. And I don't think there is any question of the fact that this is going to be a custodial interrogation. Is that correct? Mr. Davis says that's correct. She was advised that an arrest warrant had been secured for her. The court says she was properly Mirandized. Mr. Davis says she was. And the court says she was properly Mirandized. Mr. Greg Davis says, Judge, I think we can cut to this. I'm going to limit my direct examination of Mr. Parker to the areas that we discussed yesterday during the defendant's testimony. I don't intend to go through all 3 hours that he spent with her. And the court says, well, fine. With that understanding, then I am going to admit it, and I'll make the appropriate findings of facts and conclusions of law. Mr. Mulder says, Judge, why don't we find out what it is? Mr. Davis says, yes, sir, I can summarize it. And the court says, can you summarize it quickly? Mr. Davis says, yes, sir, I believe Mr. Parker is going to testify that he met with her on June the 18th. He did Mirandize her, that she agreed to talk with him, that during the course of that conversation that he had with her, he did, in fact, have her voluntary statement with him, that he showed that to the defendant, that he gave her the opportunity to read the voluntary statement. that she did, in fact, appear to read the voluntary statement, and that he asked her whether or not the contents of that voluntary statement were true, and she stated that they were. We also intend to ask Mr. Parker about whether or not he confronted the defendant about whether or not she had her children on more than one occasion during the conversation. He will testify that he did. He will testify that she never denied her children, and that when confronted that she said, quote, "If I did it, I don't remember." And I believe those were the areas that the defendant testified about yesterday. And the court says, all right, fine. If you will raise your right hand, please. So at this point, the witness is sworn in by the court. And Mr. Hagler says, just so the record is clear, Your Honor, we again would re-urge our objection to any and all testimony for the previous reasons stated. The court says, thank you. Overruled. Mr. Hagler says, could we have a running objection to his testimony? And the court says, yes, thank you. You may. All right, bring the jury in. So at this point, the jury is brought into the room, and the court informs them that the witness has already been sworn outside of their presence. And then he calls on Mr. Davis, and Mr. Davis says, thank you, Judge. And at this point, the questioning begins of William Parker. Sir, would you please tell us your full name? My name is Bill Parker, William M. Parker. All right, Mr. Parker, are you presently employed as a private investigator in Dallas? Yes, sir, I am. Do you own your own business at this time? Yes, sir, I do. How long have you been employed as a private investigator in Dallas, sir? Since 1985. Now, prior to 1985, would you tell the members of the jury how you were employed? I was a police officer for the city of Dallas. All right. How long? And the court says, you may have to speak a little bit louder because the jurors at the end have to hear you. And the witness says, okay. And Mr. Davis continues, how long were you a member of the Dallas Police Department, sir? 20 years. All right. And when you retired from the Dallas Police Department in 1985, what section or division were you assigned to? I was assigned to the homicide unit. What were your responsibilities in that section? I was a first-line supervisor. All right. And how long had you been assigned to the homicide division? 11 plus years. Okay. In the course of the 11 plus years that you spent in the homicide division, I take it that you had occasion to investigate homicides. Is that right? Yes, sir. Can you give the members of the jury an estimate of the number of homicides that you investigated during your career as a Dallas police officer, sir? 300 a year. Actual murders would be a conservative figure. All right. Sometimes 400, but 3 would be safe. Would it be fair to say then that you were involved in, say, 3,000 to 4,000 homicides during your career? Yes, sir. And during that time period, did you have occasion to interview persons accused of homicides? Yes, sir. Many of them. Can you give us any number there of the number of interviews that you may have conducted with persons accused of homicide? Several hundred, probably several hundred, possibly as many as 1,000. Okay. Sir, I want to direct your attention now to June the 18th of 1996. And on that date, did you have occasion to go to the Rowlett Police Department? Yes, I did. And directing your attention to sometime after 6 p.m. on that date, did you have occasion to meet an individual by the name of Darlie Lynn Routier? Yes, sir. Do you see that person in the courtroom this morning? Yes, sir, I do. Could you please point her out? The lady over here to my left in the gray jacket. Okay. Sir, when you first met Darlie Routier, where were you in the Rowlett Police Department? We were in an interview room type area in the Criminal Investigation Division. All right. At some point then, did you meet where it was just you and Mrs. Routier together? Yes, sir. All right. And did she know who you were? Yes, sir. Okay. Did you discuss with her why you wanted to meet with her? Yes, I did. All right. And did you, during the course of that conversation, give Mrs. Routier her Miranda rights? Yes, sir, I did. What was the purpose of you giving those Miranda warnings to Mrs. Routier? Well, it was my understanding it's a requirement of the law. Even though I'm not a police officer, I'm acting as their agent. It's a requirement of the law to give those warnings and admonitions before any discussions. So it's my understanding the Rowlett Police Department had requested that you come there for the purpose of speaking with Mrs. Routier. Is that correct? That's correct. Even though you are not still an active police officer, you did give her the same Miranda warnings that an active police officer would give her. Is that right? That's correct. And can you demonstrate for the jury how you gave those warnings to Mrs. Routier that evening? Demonstrate. Yes, sir. Yes, sir. I read them from a standard card, Miranda warning card. Okay. Do you have one of those cards with you this morning, Mr. Parker? Yes, sir. Could you read those warnings this morning in the same way that you read them to Mrs. Routier that evening? Yes, sir. Quote, you have the right to remain silent and not make any statement at all. Any statement you make may be used against you at your trial. And I stopped at that point and asked her if she understood that right. What was her response? She indicated yes, that she did. Okay. Quote, any statement you make may be used as evidence against you in court. Unquote. And again, I stopped and asked her if she understood that right, and she indicated that she did. All right. I then read item 3, quote, you have the right to have a lawyer present to advise you prior to and during any questioning, unquote. And I stopped at that point, and I asked her if she understood that right, and she indicated that she did. Quote, if you are unable to employ a lawyer, you have the right to have a lawyer appointed to advise you prior to and during any questioning, unquote. And I stopped there and asked her if she understood that, and she indicated that she did. Quote, and you have the right to terminate the interview at any time, unquote. And I asked her if she understood that, and she indicated that she did. All right. Mr. Parker, while you were giving those Miranda warnings to the defendant, did she appear to understand what you were saying to her? Yes, sir. Did you believe that her responses were appropriate to the questions that you were asking her? Oh, yes, sir. Did she appear to be impaired in any way during the time that you were giving those warnings to her? No, sir, not at all. I believe that I asked you previously whether or not she appeared to know who you are. In fact, had you met her briefly the day before? Yes, sir, I had. And had you introduced yourself to her? Yes, I did. Okay. Now, after you gave the Miranda warnings to Mrs. Routier, did you begin having a discussion with her? Yes, I did. And sir, let me ask you, during the course of that discussion that you had with the defendant, did the subject of her voluntary statement come up? Yes. Did you have a copy of her handwritten voluntary statement with you at the time that you were speaking with her? Yes, I did. Do you know the statement that we're talking about? A 10-page handwritten statement in her handwriting? Yes, sir. Is that the one you are speaking of? That is the one I'm speaking of. Yes. Did you show that voluntary statement to Mrs. Routier? Yes, sir, I did. And did you ask Mrs. Routier to read that voluntary statement in your presence? I didn't ask her to read it. I showed it to her and suggested that she read it. All right. What did she do when you suggested that she read the voluntary statement? She appeared to be reading it. She looked at it. Okay. Can you demonstrate for the members of the jury what you mean when you say that she appeared to be reading the statement? Well, I placed it on the table and she appeared to be reading it. From time to time, she would use her finger. She gave every indication that she was reading it. All right. Mr. Parker, let me show you Defendant's Exhibit 76-A. And does that appear to be the voluntary statement of Darlie Routier that you handed to her on June the 18th, sir? Yes, sir. It's a copy of it. All right. And again, when she took that document from you, again, with the documents now in your hand, can you demonstrate what she appeared to do with it in your presence? Yes. Okay. For the record, you have been looking at pages and you have been following with your finger as you went along. Is that right? Yes, sir. Did Mrs. Routier, to your knowledge, look at all 10 pages of that voluntary statement while you were with her? Yes, sir, I believe so. It appeared that she did. She took more time on some pages than others. You did it fairly quickly there for the jury. How much time did Mrs. Routier spend looking at that voluntary statement, sir? 3 or 4 minutes. She went through the first few pages of it pretty rapidly. She took a little longer on some of the others, and then she went through the closing pretty quickly. All right. When she concluded with the voluntary statement, Did you have a discussion with Mrs. Routier about whether or not she wanted to make any changes, corrections, or any alterations to that voluntary statement, sir? Yes, I did. What, if anything, did you say to her? I asked her if, since the time she had given that statement, if she had had anything else had occurred to her that she needed to add to this, or she would like to add to this, or if there was anything in there that didn't express what she was trying to express that she needed to clarify. Okay. And what was her response? No, that is exactly what happened. That is exactly what happened. That is exactly what happened. Okay. Mr. Parker, I now want to turn to another subject. During your discussions with Mrs. Routier, first of all, how long were you with Mrs. Routier that evening? About 3 hours. And during the 3 hours that you spent with her, were there occasions, sir, where you confronted her with the fact that you believed that she had for children? Yes. Do you have an estimate of the number of times that you confronted the defendant with that? At least 6 times, probably absolute minimum, 10 or 12 times, a dozen times maximum. Okay. And during the times that you confronted her with that, did Mrs. Routier ever deny her children? No, sir, she did not. Do you recall what statements, if any, that she made to you when you confronted her with the fact that you thought she had her children? Yes, sir, I do. She always had the same verbal response. Quote, if I did it, I don't remember. On one occasion, she just didn't respond at all. She just shrugged her shoulders. Mr. Parker, at the conclusion of your conversation, was the defendant placed under arrest? Well, it was my understanding she was under arrest at the outset of our conversation, and I explained that to her. I take it then that the Rowlett Police Department then took her into their custody at the end of your conversation. Is that right, sir? Oh, yes, sir. Mr. Davis says, I'll pass the witness, Your Honor, and the cross-examination is begun by Mr. Douglas Mulder. Mr. Parker, just a thing or two. You said you were a homicide officer for about 11 years. Yes, sir, that's true. And that was from what period to what period? 1973 to early part of 1985. All right, 73 to 85? Yes, sir, that's correct. All right. And approximately how many murders were committed in Dallas County during each year? Just approximately. Oh, Mr. Mulder, it varies quite a bit. 3 to 500? Yeah, each year it got more and more. I don't recall the stats. Would it be fair to say that it probably ranged anywhere from 400, probably, in the county, on up to maybe 500 or 550? I don't remember it ever breaking 500. I can get that information for you exactly, if you'd like. No, if we've got it approximate, that is fine. But you don't recall it breaking 500? No, sir, I don't. Okay, so fair to say, it ranged from what, a low of 300 to 500, maybe? No, sir, I would say it's 3 to 400. 3 to 400? That is my best recollection. I'm talking about in the county? Well, I'm not certain about the county. I'm talking about the city. I misunderstood you. I'm sorry. Well, maybe I didn't make myself clear, but there would be perhaps another 100 that occur in the county outside of the city of Dallas. Is that not a fair statement? I think that would be a fair guess. Yes. Okay. So if there were 300, say in 1973 in the city of Dallas, it might be another 100 or so in the rest of the county of Dallas? Might be. All right. Fair to say that probably 70 to 75% of the murders committed in Dallas County are committed in the city of Dallas? Again, it's a guess. I would say that would be a fair estimate. Yes, sir. And the vast majority of those that are committed outside of the city of Dallas are probably committed in Grand Prairie, Mesquite, Irving, and Garland. Would you not say the major suburbs of Dallas? I would assume that, but I really have no idea. Okay. I would assume that would be all right. Well, that makes sense though. Logically so. Yes, sir. There are probably not many murders committed in the unincorporated areas of Dallas County. Would that be fair to say? Well, yes, sir. The city absorbs the lion's share of the county of Dallas. So, yes. Okay. And the vast majority of Dallas County is incorporated by one city or another, isn't it? Yes, sir, it is. Okay. So those falling under the sheriff's jurisdiction, which would be the unincorporated area of Dallas County, would be very few, wouldn't they? Well, 10 or 12 a year? When you say under their jurisdiction, I'm not sure that I understand what you are asking me. They have a county-wide jurisdiction as police officers. Yes, sir. But as a matter of fact, Mr. Parker, the sheriff in Dallas County, the only area he patrols is the unincorporated areas of Dallas County and any small suburb with whom he might have a contract. Is that not fair? I think that would be, in terms of patrol, that would be true. They're very active. The county is very active in terms of their assistance to the smaller police departments throughout the county. In terms of the physical evidence units and that sort of thing, they become active in many of those areas. Garland has their own, of course, police force and physical evidence unit, don't they? Yes, sir, I believe they do. And so does Irving, and so does Grand Prairie, and so does Mesquite, don't they? I know Mesquite does. I don't know about the others. I assume they do. Well, you work with Irving some, don't you? No, sir. If I have done anything for Irving, it's been so long, I don't remember. I'm sure I may have at some point in time. All right. There are, other than the major suburbs of Dallas, there are probably another, 14 or 15 or 16, maybe little suburbs that Sunnyvale, things like that in the county of Dallas? Yes, sir. Oh, I'm sure there is. Yes. Now, Mr. Parker, I would assume that you were called in as an advisor in this case. Yeah, I think that would be a fair characterization. Okay. And were you paid for your services? Well, they agreed to pay me. I have not been paid. Have you submitted a statement yet? No, I haven't. All right. You expect to be paid by them? Yes, I do. Okay. And how do you charge for something like this, where you come in as an advisor? I made an agreement discussed it with the chief of police. Okay. And would you share that with us? The discussion or the agreement? Well, just tell us the dollar amount. You want the amount? Is that what you want? Yes. $1. Okay. So you are basically just doing this as a gratis? Basically, yeah, exactly. Okay. $1. Well, I assume that you have not been paid yet, though. Have you? I have not. All right. In fairness, I have not invoiced them yet either. I assume you will be paid for your reimbursed for your expenses, won't you? I hope so. Yes, sir. Okay. The DA's office taking care of your room and board and that sort of thing? They haven't yet. Well, you haven't checked out yet, have you? No. Did you come in last night? Yes, sir, I did. Did you drive down or fly down? I flew down. To San Antonio? Yes, sir. Now, did you call Rowlett or did they call you? They called me. Okay. And do you know who called you? Do you recall who called you? No, it was one of the detectives, I believe. I don't recall which one. Okay. I don't know. Until I was involved out there, I don't know many of those people on a personal basis. Okay. Hadn't worked with them before on any cases of theirs? Never. Okay. And don't remember who called you? No, sir, I don't. Okay. Did you go out there? I guess the 17th. I think it was the 16th, but I'm not certain about that. 16th? Okay. A couple of days before the arrest was made. Okay. And did you meet with the detectives out there? Yes, sir, I did. Okay. And was your purpose in meeting with them to go over their reports or their evidence? Yes. Okay. And do you recall who you met with out there? There were a lot of them, Mr. Mulder. 6 or 8? 6 or 8, probably. Yes. Okay. You met in one of the conference rooms out there, did you? Yes, we did. The chief was there, I guess, wasn't he? He was. And you formalized your agreement at that time, I suspect. I did. Okay. And how long did you go over the evidence with them? I spent most of that day out there, several hours. I didn't keep up with the time, most of the day and late into the evening. Yes, sir. Did you go out to the scene? Not at that time. I did subsequently. When did you go out to the scene? The following day. I think it was the 17th, but I'm not certain. Okay. How long did you spend with them, Mr. Parker, on the 16th? I'm sorry. How long did you spend out at Rowlett the 16th? The police department? Yes, sir. The first day out there? Yes, if that was the 16th. I think it was the 16th, 7 or 8 hours. 7 or 8 hours? I think so. Yes. Okay. And that was spent interviewing the officers? No, it was not. Okay. Did you look at photographs? I looked at photographs. Okay. Did you look at all of the photographs that were taken? I looked at a considerable number of them, several hundred. It was a considerable number of photographs. I, of course, didn't count them. A lot of photographs. Did you give them any suggestions on taking photographs? No, I did not. Were you able to piece together what had happened through the photographs or at the crime scene? Yes, sir, to some degree. That and a sketch of the floor plan. Did you think it was curious that they didn't have overall shots of the scene like you would get if you backed into a corner and shot all around, went to another corner and went to various extremities of the room? Well, they did. They had a video that I looked at, a video that showed great detail. You have looked at a video? Mm-hmm. Okay. How about photographs? Did you find any photographs that were shot from the extremities of the room? And not that I recall. Okay. Most of them appeared to be pretty tight shots, as I recall. Mr. Parker, did you interview the paramedics? No, sir, I did not. Did you review any of their reports? No, sir, I don't believe I did. Okay, is it fair to say, and when you talk about 300 or 400 cases a year that you, as a supervisor, familiarize yourself with, you are not talking about going to the scene of 300 or 400 murders a year, are you? No, sir. You are just talking about reviewing. I assume you reviewed the homicide reports that came into your unit? Yes, of course. I reviewed every one of those, and I would say I went to the scene at least half of those now. You go out on many death cases, a couple of hundred or 200 or 300 a year, that sort of things. Okay. Those would be, I take it, the cases in Dallas that you saw. How many would you handle personally? I had some role in at least half of those cases, probably more. Would that be just going out to the scene and making suggestions to the officers to whom the case was assigned? In some cases, more often than not, I had a more active role than that. Okay, you would take part in interrogation of the witnesses? Yes, sir. Okay. And many times interrogating the suspect or the accused? Yes, sir. Okay. But at any rate, with the crime scenes that you have seen, Mr. Parker, is it not fair to say that practically all crime scenes are contaminated to one degree or another? Yes, that is fair to say, isn't it? I agree with that. Okay. And it is especially so if there have been paramedics or the first responders on the scene were paramedics. It's especially so, isn't it? Yes, sir. That is a common problem at crime scenes. Okay. And you can multiply that if there are multiple victims, can't you? Well, I don't know about that. Well, it has to do with the size of the physical area more than I would think the number of people there, if I am understanding your question. Well, maybe we could say the more victims involved and the smaller the area, the more confusion there is many times. Well, yes, but on the other hand, if it's confined to a smaller area, where the limits of the crime scene actually stopped, it's undetermined at that time. Okay, but would it, in your judgment, contaminate the scene if there were 6 or 7 paramedics on the scene rendering some sort of emergency assistance to the victims? Well, it could. Well, I think if I'm following your question, there is always going to be something characterized as contamination. There is always going to be something changed there when people are involved. They are going to move things, change things. Sure. Is that what you are asking me? Yes, sir. That is what I am asking you. Yes, sir. And perhaps paramedics are less, maybe conscious, of the evidentiary value of certain objects than police officers are. Would that be fair to say? Yes, I think so. Their focus is on victims, and I think that would be fair to say. Yeah. And you have seen situations, I dare say, where paramedics have moved pieces of evidence? I have, yes. Okay. And matter of fact, you have seen cases, have you not, where police officers have moved evidence? I have, yes. Everybody wants to touch the gun, don't they? It's a common concern. Yes, sir. Okay. And everybody wants to see where it happened, don't they? Everybody wants to come in and look around. Mr. Parker, everybody wants to get a drink of water. Everybody wants to use the bathroom, don't they? That is a common problem. Yes, sir. Okay. Now, when going through the crime scene many times, Mr. Parker, don't you find that officers in their walkthrough or in their curiosity have actually kicked evidence around? Yes, such as not this case, but such as cartridge cases in a shooting where cartridge cases are ejected, they will kick them around on the floor. Yes, sir. In cases where there is traffic and there might be objects on the floor, those could be kicked around. Those objects? Yes. Small objects? Yes, of course. And you have seen that happen, haven't you? Of course. Yes. And it's not unusual? It's not unusual. No, sir. Mr. Parker, you are a skilled interrogator, are you not? I have spent a considerable amount of time doing that. Well, I mean, don't be modest. You're a skilled interrogator, are you not? By definition, I'll leave that to you. Well, I think you are. And when you interrogate someone, of course, it would be fair to say that you would have the advantage, would you not, with your experience? It depends on who you're talking to, Mr. Mulder. Well, let's say you are talking to a 26-year-old who has not had any experience with the police as opposed to a five-time loser who has been in and out of the joint most of his adult life and is maybe, well, can you define this advantage that you are speaking of? So I might be, well, you are certainly more mature and more experienced, are you not? More than a 26-year-old? I am now, yes. Than, say, Darlie Routier would have been or was at the time that you talked to her? I'm more mature then and now, yes. All right. Now, Mr. Parker, can you tell us basically what you understood about the evidence at the time that you first talked to her? What I understood about the evidence? Yes, sir. Well, I understood that the call came in about 2 o'clock that morning, and the report was that there was an intruder there. There were obviously two children. The investigation of the evidence that was passed along to me indicated that it couldn't possibly have happened that way. The evidence was in direct contradiction to the way the crime was reported to have occurred. Okay, I can give you more details about that. Yes, did they discuss with you the screen that had been cut? Yes. Okay, and did you have access to Mr. Lynch's report? I didn't see any written report from Mr. Lynch, but I was informed that I recall. But I was informed, I recall clearly, that the knife that was used to cut the screen was found in the kitchen in a block that contains knives, a block that the knife had been found there that was used to cut that screen. They just gave you the shorthand rendition? Yeah, I don't think Lynch had even prepared a report at that time. I don't remember reading. Did you talk with Charlie Lynch? Not about this, no. Okay. Did they, when they gave you the information on the screen and the knife, did you see the knife? No, I saw a picture of it. Did they tell you that it was a bread knife, Mr. Parker? A bread knife? This is not the knife, but did they tell you that the knife that had been used to cut the screen was a bread knife? No, they didn't. No. Okay. Did they tell you, they just told you that they had the knife that had cut the screen? Yes, they told me it came out of that set. Okay. Of knives that was in the kitchen. Well, did they tell you that actually what Mr. Lynch had told them was that he had, after the knife had been processed for fingerprints, that he had examined the serrated blade of the knife, and in some area, approximately 1 inch in from the point and approximately 5 inches from the point, in this area right in here, that he had found a fiberglass, what appeared to him to be a part of a fiberglass rod, and that the screen threads, the threads of the screen that made up the fabric screen on that window, that each of those threads had approximately 50 fiberglass rods in it, and that they were covered with a rubber-like PVC material, and that he found one of those fiberglass rods on that knife and found some rubber dust, and that he couldn't say that the rubber dust and the rod had actually been together at any time. In fact, the only thing he could do was compare the rod and the rubber dust with PVC from the screen and the fiberglass from the screen and say that they appeared under a microscope to be the same, and that the objects on the knife were so minuscule that he couldn't subject them to any sort of scientific test to determine whether or not these items on the knife actually came from the scene. Did they give you that much detail? Mr. Davis says, I'm sorry, I have to object to the misleading nature unless he also includes the fact that the glass material was also embedded into the rubber material, and he has stated he believes they were deposited at the same time. The court says, all right, with that statement, you may answer the question. The witness says, I'm not sure I understood the question. And Mr. Mulder continues, well, I just wanted to know if he told you that if they gave you the absolute and told you that the knife was used to cut the screen, or if they gave you the long rendition and said simply that what they found on the knife under a microscope, that it was so minuscule, one, that they couldn't subject it to any sort of scientific test other than a microscope, and two, that all they could say was that it appeared to be the same as the screen. And that meant it was consistent with having come from the screen, but it could have come from someplace else as well. Did they give you that much detail? Well, they told me that Charlie Lynch, who I have known for many years and have great confidence in, had examined the knife found in the kitchen, and that it was his firm conclusion that that was the knife that was used to cut that screen due to some material or some process that Mr. Lynch had used. They didn't go into great microscopic detail. And you would suspect then that he would tell this jury the same thing if he were under oath, wouldn't you? I would expect he would. Who would tell the jury what? Mr. Lynch would. I feel Mr. Lynch could probably explain it in much better detail than I could. All right. But you would suspect that Mr. Lynch would tell this jury the same thing that you understood that he was the position he was taking? Basically, sure. Okay. Were you also told, Mr. Parker, that Mr. Lynch had identified one of the defendant's blonde hairs in the window? No. You were not told that? No. Okay. No. Did Mr. Lynch, this man in whom you have great confidence, did he ever tell you that he had initially identified a hair on the window as being that from the defendant? No, sir. As I told you, I didn't talk to Mr. Lynch. Okay. But he didn't tell you in a subsequent conversation? No, I have not had any conversations with him about this case at all. All right. So you had heard about the screen. Is that right? Mm-hmm. Yes, sir. Okay. And did they tell you that the mulch outside the window had not been disturbed? They did. Yes, sir. And did you put significance in that? Some, not an overwhelming significance. Why did you put significance in that? Why did I put significance in the fact that the mulch was undisturbed? Yes, sir. Well, someone leaving in haste from a murder scene, you would assume is going to be very bloody. In their haste, you could expect to see some disturbance there to one degree or another. Why would you expect to see that? I mean, you can only draw a fair conclusion from what you do see versus a safer assumption from what you don't find. Okay. Why would you expect to see some disturbance in the mulch? Well, it would be a distinct possibility, Mr. Mulder, that someone would step in that in their haste. But why would they step in the mulch? Because it's there and it's kind of in the way. Oh, you were led to believe that the mulch was in the way and they would have to step in the mulch? Well, I looked at the photographs and I wouldn't say you had to step in it, but it would be very easy to do. Yes. The mulch is actually in a flower bed, isn't it? Yes, sir, as I recall. Or did you think that the mulch was below the window? I was thinking the mulch you were referring was going to be outside the fence. Outside the fence? I thought that was what you were referring to. Out in the alley part? I suppose you could characterize it that way, outside of the fence. Could you show me the photograph, Mr. Parker, where the mulch has the mulch outside in the alley? I don't have any photographs with me. Okay, but that was significant to you, the mulch in the alley. Was it? I said it was some sort of significance, Mr. Mulder. I said it's not overwhelming. Okay. Did the fence, was that significant to you? Somewhat, yes, from what I understood that it would be. What did you think was significant about the fence that kept the mulch, I guess, out of the backyard? What? No. I'll be fair with you. There isn't any mulch in the alley. Okay. Okay. What was significant about the fence? Well, what I recall being significant about the fence, it was white. I was informed that the gate was very difficult to close. that it was closed when the officers arrived, and it takes a considerable amount of effort to open and close it. The fact it seemed inconsistent with a person leaving a murder scene to stop and close that gate. The only other alternative would be to crawl over it. Painted white, I was informed that there were no blood marks, no shoe scuff marks on this white fence. That outside there was a flower bed, soft earth, where if a person did vault over a fence that high, you might expect to see some imprints, and there were none. Why would someone vault over the fence when they could go through a gate? Well, was it just for a challenge? I don't know, possibly. Yes, it doesn't fit. It doesn't make sense that they would do that. It doesn't make sense that they would close the gate. What I was informed was that that gate was very difficult to deal with. You might vault over the fence. You were not advised that the gate had been worked on that night? Worked on? Mm-hmm. No. You weren't? No. And that was verified by the neighbor behind the Routier's house? No. Okay. I don't recall anything about that. Did you look at the gate yourself? No. Okay. You don't know whether it had a scuff mark on the bottom of the gate where someone had perhaps pushed against it? No. Okay. You said that someone would be very bloody from this scene. Is that right? Well, you could certainly expect to see some blood on them. I would assume. Yes. What, blood on their hands? I would think that would be a safe assumption. Yes. Blood on their hands? Yes. Okay. I mean, blood that you could just wipe off? I think you can wipe blood off. Yeah. You wouldn't expect their hands to be dripping with blood, would you? Quite possibly. Yes. I mean, would you? Yes. Quite possibly. Yes. Both hands? Quite possibly. Yes. Okay. Did you determine how many knives were used in the commission of this offense? I was informed that at the time that I was there, it appeared from the preliminary information to the investigators that there was only one knife. Only one knife used? That is what I was informed. Yes, sir. Okay. Did you accept that at face value? Sure. Okay. Would it change your opinion if more knives were involved? Change my opinion about what? About anything? No. Okay. So it really didn't make any difference how many knives were involved? Nothing significant that I can think of. No. Okay. Did you interview Mr. Routier? No. Why not? I met with him and talked with him very briefly. You talking about introduction? Less than 30 seconds? No longer than that. A minute? Couple, 2 or 3 minutes. 2 or 3 minutes? Yes, sir. You just introduced yourself and said hello? Yes, sir. I told him I was involved in the case. Was that before or after you interviewed Mrs. Routier? Before. Before. That same day? Same day as what? The same day that you interviewed her? Yes, they were both together. Okay. Were you alone when you were interviewing Mrs. Routier? Yes, sir. Okay. At the police station? Yes, sir. You were put in a what? An interrogation room? We were in rooms they use for interviews there. Yes. Okay. Did it have a two-way mirror? No. I asked them if they had a room that had a recording device, a camera, or a mirror that we could use. They had none available. Didn't have anything available? No, sir. When did you ask them about that, Mr. Parker? The night I talked to her. Okay. The night she was arrested. Had you decided to interrogate her before that day? Yes, sir. Had you decided on the 16th or 17th or what? Probably the 17th. It was the day before she was arrested. Okay. And of course, like you say, the sheriff is cooperative. That could have been done at the sheriff's office, couldn't it? Interview? It could have been, I suppose. I mean, if you wanted to record it, you certainly had. You've got a video camera yourself, don't you? I do. You could have brought your camera, couldn't you? Well, I could have, yes. I have got several cameras I could have brought, but you have recording devices as well, don't you? Mm-hmm. Matter of fact, you could have done it in your office, couldn't you? Sure. All right. Well, I take it just you and Mrs. Routier were in the room together? That's correct. No one else? No, sir. Okay. Was there a microphone in there so that the other folks could monitor what was going on between the two of you? Not that I'm aware of. I asked them if they had one, and they intended to try and record it if they did have one. They said it was still out at the cemetery? No, sir, they didn't say that. Mr. Davis says, we're going to object to that. And the court says, sustained. Mr. Davis says, if we could have an understanding, I thought we did. The court says, Mr. Mulder. Mr. Mulder says, yes, sir. The court says, let's stick to the points we have all agreed to. Mr. Mulder says, well, Judge, I was just asking if the court says, well, Mr. Mulder, you know what was agreed to and stay with it. Is that clear? Thank you. Ask your next question. What was agreed to, Judge? I don't recall agreeing to anything. The court says, all right, Mr. Mulder, hearings have been held in this case. Mr. Mulder says, well, I understand hearings have been held, Judge, but I take issue with the court when you say I've agreed to something. Now, I'll abide by the court's rulings, but I have not agreed to anything. The court says, well, the court has made a ruling there. Let's move on to the next question. Mr. Mosby says, the court has not made a ruling with respect to this witness. The court says, no, just ask the next question, please. Mr. Mulder says, well, that was my next question. I was going to ask it again. The court says, well, then ask the following question, please. And Mr. Mulder continues. That was not a high priority, recording the conversation. Was it, Mr. Parker? Or was it? Maybe it was. I would have preferred to have it recorded if they had it available. Yes. Well, you knew going out. You have recording equipment yourself, don't you? Well, yes, sir, but it would have had to have been something that you would put up in the middle of the table, a small recorder, something of that sort, or a big camera on a tripod. I don't prefer to do that. That is very distracting. How do you like to do it? Surreptitiously? Well, surreptitiously in the sense that if that means secret, no. I think it would be unfair to record someone and not tell them that you are doing it. But I have that, for example, in my office, the camera is visible there and make it clear to them that they are being recorded. Okay, suffice it to say that that was not a priority, or you could have done it at your office or done it at the sheriff's office, or Richardson's has some fine recording equipment, don't they? Well, it's not a priority, and the reason it was easier to do it at Rowlett is because you don't know how things are going to develop there, and it's their agency. It would seem the logical place to do it would be the Rowlett Police Department. There was not any big discussion about that. That was not a point of concern to anyone. Mr. Parker, was the press, had they all been notified, the media, when you got out there? Got out where, Mr. Mulder? Got out to the Rowlett Police Department, Mr. Parker. Oh, I'm sure they were. They were already out there? I saw some of those mobile units there on the parking lot. They were there before the Routiers got there, weren't they? Well, are you talking about on the night they arrived? The Routiers arrived at the police department? Yes, sir. I was already inside. If they were there when I got there, I assumed they were still out there, but I have no idea. Okay, so, and I take it you did not alert them? Absolutely not. So it must have been someone there at the Rowlett Police Department? Well, I don't have any idea. Well, you could probably make that assumption. No, I wouldn't make that assumption. With a case of this nature, they generally, it's my experience, they stay real close to the police departments. No one has to notify them. They are pretty good about finding out themselves. Okay, did you make any notes, Mr. Parker, during your interrogation? No, I did not. Okay, did you make any report after you had concluded your interview? No. You just weren't asked to make a report? No. When is the last time that you talked with the district attorney's office? I talked to Mr. Davis this morning. Did you talk to him last night as well? Mm-hmm. And about how long did you talk to him last night? About 15 minutes. Okay. Who picked you up down in San Antonio? One of the district attorney's investigators. Which one? Do you remember? Mrs. Kinney. Just the two of you? Yes, sir. Okay. What time did you come in last night? I think I arrived at 5 o'clock. Okay. Arrived in San Antonio at 5 o'clock? Yes, sir. Got back up here, I guess around 6 o'clock or so? Oh, a little later than that, 7 o'clock, I think. Okay. Now just, Mr. Parker, talking about your techniques in general, not in this particular case, but when you interrogate someone, I suspect that it's part of your technique to be friendly with them at first. I try to be friendly all the time, Mr. Mulder. Well, it depends on how cooperative they are, I guess, doesn't it? No, I don't think so. Okay, but I guess in that vein, you attempt to, I assume, get their confidence, don't you? Well, I don't think you are ever going to get their confidence, Mr. Mulder. Okay. If I understand what you are saying. All right. But you are friendly? Sure. And try to be nice to them? Try to be. Yes, sir. And in this case, you were nice to Darlie, weren't you? Absolutely. Okay. Did you discuss with her the evidence that you understood the Rowlett Police Department had? Yes, sir. I showed her a copy of it. I showed her a copy of the affidavit for the arrest warrant. Okay. She looked at it very carefully. All right. And did you also have the benefits of her husband's statement? Had the benefits of it? Yes, sir. Yes, I had read it. And at this point, the judge allows the jury to take a 15-minute break. So this recess is taken. And when everybody is back in the room, Mr. Mulder continues. I don't know whether this is an evidence or not, Judge. And Mr. Mulder then continues his questioning of the witness. But let me show you what's been marked for identification and record purposes as Defendant's Exhibit number 98 and State's Exhibit number 141, Mr. Parker. Defendant's Exhibit 99, Mr. Parker. Is that the statement that you read that you understood was given by Darren Routier? Yes, sir. And you say you talked to him for very briefly. Okay. And you had no reason to doubt this account, did you? No. All right. And based on your evaluation of the situation and your conversations with the Rowlett Police Department, you believe this was truthful, didn't you? For the most part, I didn't see anything there that indicated to me that he was involved in the crime. Well, and I don't recall anything standing out in my mind as being I had a big problem with, but it's been a long time since I've looked at it. Yes, sir. Mr. Parker, during your 3 hours that you spent with Mrs. Routier, she was polite to you, wasn't she? Yes, sir, I would say so. Okay, and I guess Mr. Mulder then says, I believe that's all. Thank you. And then the redirect begins by Mr. Greg Davis. Mr. Parker, I just have one question. Since you left the Dallas Police Department, has Mr. Mulder ever employed you? Yes, sir. On more than one occasion? Yes, sir. Mr. Davis then says no further questions. And then the ReCross is begun by Mr. Mulder. We're personal friends, are we not? Yes, sir. Okay, I believe that's all. Thanks. Mr. Davis says no further questions, and the court says, all right, thank you, sir. You may leave. And Mr. Davis says, yes, sir. Your Honor, ladies and gentlemen of the jury, at this time, the state of Texas rests his case in rebuttal. And the court says, all right. And I believe, thank you, Mr. Davis, that's all the rebuttal testimony you will be hearing from the state's witnesses. And you will be ready at 1:30. Is that correct? Mr. Mosty says, our witnesses, I believe they are in transit. I think we can be ready by 1 o'clock because I think they will be arriving. Well, I don't know what time, 12 o'clock? Mr. Mulder says, we ought to be ready by 1 o'clock. I wouldn't think that it would take more than an hour and a half or two. And the court says, well, to be on the safe side, let's be on the safe side. Let's make it 1:15 if everybody will be back by 1:15. And Mr. Mulder says, Judge, I want them to know that we won't take more than about an hour and a half. So if they have got, and the court says, we understand. So if the jury will be back at 1:15, please. The same instructions as always. Do not discuss the case amongst yourself. And then the judge continues to go on and give them their usual instructions. And that is the testimony of William Parker. Okay, so let's do our usual recap and start with the prosecution questioning Mr. Parker. Greg Davis asks if he told Darlie why he was meeting with her, and he says yes, but that's it. What did he tell Darlie he was meeting with her for? I'd be curious to know exactly what was said to her. He said he read her Miranda rights and she indicated that she understood. But how did she indicate that? Did she nod? Did she say yes? How exactly? He also says that after she has read over her own handwritten statement, he asked her if she wanted to make any changes to it. And she told him, quote, no, that is exactly what happened, unquote. He's with her for 3 hours and said that he confronted her saying he believed that she had her children. And he said that he did this at least 6 times, an absolute minimum of 10, and 12 times at the most. He claims that she never denied her children, which I personally find very hard to believe. He then said that she made the statement, quote, "If I did, I don't remember," unquote. He even said that on one occasion, she never even responded. She just shrugged her shoulders. He further said that he explained to her that she was under arrest before he began to question her. And what else? What else happened in that room? He was with her for 3 hours. So when the defense begins to question Mr. Parker, my first thought was, there's all kinds of questions that he's asked by the defense. He doesn't remember who called him from the Rowlett Police Department to come in and do this interrogation. He doesn't recall the date that he got into town. When he got to Rowlett, he couldn't recall who all he met with. He couldn't quite remember how long he spent going over the evidence. He couldn't remember the date he went out to the Routier home, yet he could recall exactly what he said to Darlie and how she responded when shown her statement, and then what she said while he was interrogating her. We also find out that there was a video taken of the scene. Now, this so far has never been brought up in court before. Parker says that during his career as an officer in Dallas, part of his job was reviewing the reports that were taken regarding homicides. So he's familiar with how important these reports can be. He never interviewed anybody when he got to Rowlett. He never reviewed any notes, well, because there really weren't any. He never saw a report from Mr. Lynch, but he was quote unquote informed about what Lynch had found. He never actually spoke to Lynch about this case. Now, I don't know if you noticed this, but in the transcripts, and these transcripts that I've been reading, they are the updated ones without most of the mistakes. I have come across a few, but in this portion, Parker said that he understood that the call came in at 2 a.m. Now, we all know, it's on record that the call came in at 2:31 a.m. So either he was told wrong or the transcript is wrong. Now, Mulder, he never addresses this discrepancy, so I'm going to assume that it's just wrong in the transcript itself. And this was just one of those things that just wasn't fixed. When they start talking about the fence, there were a couple of things that made me kind of step back and pause for a minute. First, that the gate was closed when the officers showed up. Now, I don't have any photos showing that, at least that were in evidence, but showing the gate closed. But it may have been shown in court. I don't recall it, though. Next, they said that the gate door was difficult to open and close. Now, Darin said he fixed the fence the night of the crime. And Darlie said that she had asked him to do this. She never said, or she never followed up with him, but said that he had gone outside and, evidently had fixed the fence because she had requested that he do this because the dogs were coming over and were going to be in this backyard. Thirdly, the scuff marks not on the fence itself. Now, I remember a while back, someone testifying that because the door would stick, it was often kicked open or someone would use their foot to open or close the door. This would have left scuff marks. Something must have been there, but they're saying that nothing was found. I find that hard to believe. Now, surprisingly, when Mulder's asking these questions, he actually asks Parker if he interviewed Darin. And he said that he did not. He just spoke with him for a couple of minutes. So when it comes to Darlie's interrogation, Parker evidently said that he asked the Rowlett Police Department if they had a video or any video recording devices or audio recording devices that he could use. And they didn't, but they said that they were going to, quote unquote, try and get one. Then we find out that Parker had some he could have used. Now, whether he brought it with him or not, it's unknown. It's unlikely because you would just assume that an interrogation room at a police department would have these things, right? When he discovered this, though, that they didn't have anything to record, either video or audio, why did he still go through with the interrogation? He had to know that there wouldn't be any proof of anything. But when he's pressed about this, he then gives this, I call it an excuse, but he's like, well, if I had a recorder on the table or something or a video camera set up on a tripod, it would just be too, quote, distracting. That was interesting. When Mulder talks about or makes reference to the fact that they didn't have a microphone, the Rowlett Police Department didn't have a microphone because it was still out at the cemetery. There's this back and forth because if you remember, this was not allowed to be talked about in an earlier testimony. It seems ridiculous, I know, but even though the Rowlett Police Department put microphones at the cemetery secretly, this could not be brought up in front of the jury. And it was supposed to not be approached at all. I don't know if Mulder is just being difficult or what when he says he doesn't remember that he agreed not to talk about this. But I'll tell you, he is certainly not doing Darlie any favors by continuing to argue with the judge. And then finally, we learn that Parker, he did not even take any notes. This is a common theme with everybody. Nor did he even write a report after interrogating Darlie, even though he comes from this background where this is something that's very important, right? So that's kind of where we left off. But I just want to give you a quick warning. I got this a rant coming up. Okay, now Parker, he comes off as very confident in his answers and very matter of fact. But again, there are no notes taken. There's no audio recording. There's no video recording. There is nothing. Even though they had various locations that they could have gone to, he could have brought in his own equipment. He could have borrowed some. He could have done everything. Nothing was done. For someone who was so seasoned and had worked with the police and homicide for years, you would think that he would have known better. I have been constantly shocked at this lack of documentation by nearly everyone who investigated in this trial. Note-taking is absolutely essential, especially when it comes to serious crimes like homicides. Observations, witness statements, timelines, they're all crucial to have in order to prove your case. Yet this entire trial has been completely devoid of any of this very common practice. Even with this seasoned homicide detective, to be alone in an interrogation room for 3 hours with a suspect without any two-way mirrors, without a recording device, without a video device, or at a bare minimum notes, there's no way to check what was really said or if Darlie was even pressured at all. 3 hours is a long time. And all we heard from Parker was that the prosecution latched onto about what Darlie supposedly said. Quote, "If I did it, I don't remember." But do we have proof that she even said this at all? No. We have a guy who is so upstanding that he offered his services for $1 because he's such a great guy and just wanted to do the right thing. And I'm sure that he doesn't charge his own PI clients a single dollar, does he? I want to make it very, very clear that this is not about taking sides for or against Darlie. This trial has revealed major problems like the police not following proper procedures, being careless in the investigation, mishandling evidence, and probably the most important, violating Darlie's right to a fair process. She was interrogated without any recordings of what was said or what was done, which is a serious, serious issue. It's shocking to me that this trial was even allowed to run the full course. And that's it. End of rant. I promise. That will do it for this episode. In the next episode, we have one more piece of testimony by Richard Coons. And then we move on to closing statements. And it begins with the charge of the court. Now, Richard Coons is a physician and a forensic psychiatrist. And we will hear from him next and then move on to everything that has to do with the closing of the trial. Thank you. Thank you all so much for listening. I appreciate you so much. You have no idea. Please take a moment to subscribe to the channel, no matter where you listen. Thanks again, everyone. We'll talk really, really soon. Bye for now.